Shervin's report, which is really the only, which is the information we have about what happened during that interaction. At the end of that interaction, as I think the court's heard before, Trooper Shervin, I'm sorry, Your Honor, Mr. Hernandez tells Shervin that he needs to speak with Hernandez's attorney. Shervin then asks who that was. Hernandez says Ropes and Gray. Shervin asks who at Ropes and Gray. Hernandez goes in the house, retrieves 2 business cards, which he gives to Shervin. After that occurs, according to Shervin's report, Shervin then tells Hernandez that this was a death investigation and that he was looking for Hernandez's assistance. It's our position, Your Honor, that everything that happens after that is essentially a fruit of that improper interaction which occurred after Mr. Hernandez said, talk to my lawyers, here's who my lawyers are.
It had been agreed prior to the trial that everything, anything about you got to speak to my attorney and the alleged slamming of the door and the telling him a death had occurred and the response or non-response from Mr. Hernandez was not going to be.
Well, if I can just finish, Your Honor, it's our position that what happens after that, so the next video clip, that interaction is in clip 3. Clip 4 shows the officers again sitting in their car. If the Commonwealth wants to put that in for 14 minutes and 39 seconds, I suppose I have no objection to that. But the 5th clip, Your Honor, shows Hernandez.
Is there any objection on clip 4?
No, Your Honor. There's no objection on clips because it just shows the office. It doesn't show Hernandez. It just shows them sitting in the car.
No, so there's no objection on clip 1 of walking around. There's no objection on clip 2 of sitting.
That's right.
And on clip 3, which has the interaction.
There's no objection to them showing the video. We would object to them getting out of Detective Arrighi, who's a witness today, what Hernandez said with respect to his attorneys and all, and then what happened after that.
But there's no objection to that
video.
Okay.
That's right, Your Honor.
And there's no objection to video 4.
There's no objection to, because they want to show that. But 5, which is Hernandez coming back out of the car, having further interaction with the officers, and then leaving the home with Ms. Jenkins, basically to go to the police station. Our position is that that is a fruit of what was an improper inducement by Shervin to Hernandez to speak with them further after he invoked counsel, and that therefore we would object to 5.
But there's been never a motion to suppress that somehow his going to the station that night was the improper fruit of any illegal conversation that Shervin had.
Well, you're right.
Presented with a motion to suppress.
Well, that's correct, Your Honor, and I think
so
this
I'm
is.
not sure what the argument is. And
Well, Your Honor, you're correct that we did not file a motion to suppress on that ground. This is really kind of an argument that's occurred to us more recently. I know of no rule or law in Massachusetts that requires us to raise this issue before trial. I think we're raising it in a timely way, and I'd ask the court to consider it.
What is the argument? What is it? You're saying the fact that Mr. Hernandez went to the station is an improper fruit of what? Is that what you're saying?
Yes, Your Honor. I'm saying that.
And what's an improper fruit of?
That after he said, talk to my lawyers, here's who my lawyers are, they then said to him, this is a death investigation, we're looking for your assistance. They should not have, that is basically an inducement. I mean, it's obvious, it's not the Christian burial speech in that old Supreme Court case, obviously, but it's that kind of a thing. It's saying something to a suspect, basically to induce that suspect to speak to the police further after that individual.
Well, I don't have any affidavit to raise this issue. It may be that he spoke to his lawyer Ropes and Gray, and his lawyer Ropes and Gray, that if he went out and he said, when they originally came, before the comment on death, he said, you have to speak to my lawyer, what you've just indicated, and then he went back inside, he got a card, he came outside. It may very well be that prior to going outside, he spoke to his lawyer at Ropes and Gray, who said, it's I recommend that at this stage, we cooperate to the extent of going down to the station and see what they want. I don't have an affidavit to the extent this is a late argument that you've come up with. It doesn't mean that you don't need an affidavit to suppress something. It doesn't at all follow that whether or not that statement had been made, a decision had been made prior to that statement because of conversations with Ropes and Gray, or B, whether that the impact of that statement, if any, on the decision. So based on simply as an argument, I don't think it's in a fashion.
Well, I understand what the court is saying. I think that there's no indication from the reports that we have that there was any request of Hernandez for assistance or anything else until after he had invoked. So
I don't know what request there was.
Well, Sherman apparently said, "We're looking for your assistance."
Right. And it's...
That's a request.
It's not at all, that needs an evidentiary hearing. And it needs an affidavit from Mr. Hernandez to raise.
Okay. Well,
I will...
If I could, Your Honor.
Yeah.
First of all, you were correct when you had indicated you thought that we had an understanding about what was going to be offered and what not, what is not going to be offered. I've instructed this witness he's not to mention anything about it. We've cut off the conversation between the defendant and the police. Initially, he came out and he started the conversation. He walked over. They were introduced. There were a couple of questions that were asked. At some point after that, he turned and he started walking back. He said, "What's with all the questions?" Turned and he said, "You're not coming into my house." He then goes into the house. He says he gets a card from the lawyer, and then that's handed to the officers. We've cut the video off after he turned and made that last statement to them, but prior to saying anything about the lawyer, we've cut the video showing him returning, giving the card. What happens from there is they go back out. They're sitting in the front, the street in their car, and about a half hour goes by, and the defendant comes out of the house and says, "Okay, I'll come down to the station." And so at that time, he's resumed the contact. The defense, the argument they're making today seems to be in contradiction to the opening that it was represented that he volunteered to go down to the station.
I also note there was unobjected to testimony by one of the officers. I believe, my recollection is that he took palm prints or prints of Mr. Hernandez at the station.
That was after his arrest, I believe.
That was after his arrest. Okay.
But
what I will do, if you are representing that you are going to be filing today an affidavit to raise an issue as to whether that the coming to the station is was the fruit of something, and that would show something that would merit get over the hurdle of getting a hearing, and that there had been zero discussions with Ropes and Gray. I mean, obviously you got there are decisions that have to be made as to whether you want to pierce or not pierce attorney-client privilege. But given the evidence that I recall hearing in the past, I don't see a basis simply on the evidence in the past to trigger to rule one way or the other. I will exclude at this point Film 5 if you tell me that you're about to file this affidavit and requesting an evidentiary hearing on this issue.
Your Honor, I appreciate that. I think hearing the court's analysis, I don't think we're going to go down that road. So let me move to the second video, if I can, briefly. The second
then 5 will be allowed in.
Thank you.
With respect to the second video, Your Honor, that is a video taken at the station the morning of the 18th at about 2 a.m. I think we discussed this with the court previously, and I just don't know whether the court made a definitive ruling or invited further argument. That's the video where Mr. Hernandez is in his lawyer's car in the parking lot. And we object to that. And just to make our argument on that, Your Honor, our position is that that video basically, our position is that Mr. Hernandez, being in his lawyer's closed vehicle in a parking lot, had a reasonable expectation of privacy. What the police did, this was not just a passive surveillance.
And I do have, it wasn't clear, or at least since there's not been an evidentiary hearing on that issue.
Right.
I did go back over the notes I had that had some reference to that in one of the earlier hearings. And my recollection was that there was an officer, Bates maybe, who I think testified that 3 weeks later he saw the surveillance video and then tried to figure out what number was being called. It wasn't, there was no evidence as to one way or the other as to whether the surveillance video was taken because that camera is running, or whether, I mean, you shake your head, but I'm saying I have no evidence. There are no affidavits. There's not been a hearing. There's no evidence as to whether that surveillance video was taken because the surveillance cameras were automatically running, whether it was taken because it was specifically directed to the car, whether it was taken, whether it was manipulated or not. All of those may be relevant factors, and that would, it seemed to me, also require some sort of a hearing.
Well, on that, Your Honor, I think if the court, number one, Trooper Bates testified that the person operating the camera did a great job. And I think if the court sees the video, it's very clear that this was not a passive surveillance, that somebody is operating a camera, it is zooming in as close as possible on what Mr. Hernandez is doing and on his interaction in that car. So this is clearly that's what's going on, and I really doubt the Commonwealth would dispute that this was a deliberate effort to surveil him in his interaction in that car, his attorney's car. It was not passive, it was clearly active. There was an assistant district attorney on the premises. This was being done as a deliberate act of surveillance, and we say that that was a violation of a reasonable expectation of privacy, if not attorney-client privilege.
When the issue was first raised, I invited briefing. I don't recall whether I received.
Your Honor, honestly, we have not had time to do a brief on that.
Your Honor, this issue.
Some facts first before we get to the
Yes,
legal
Your Honor.
position. There's some facts that you're both are in agreement on.
The facts, I think, Your Honor, are that Mr. Hernandez and an individual who was identified as Robert Jones were in the parking lot, and the officer, they had left the building at some point, and one of the officers had actually earlier gone out and looked around.
In a car?
No, Your Honor, just standing out in the parking lot. And they're observed in the video out at that location. At some point, they then moved to the car, and Mr. Hernandez...
And where's the car?
The car is in the parking lot of the North Attleboro Police Station. And this is all well lit, the camera's on the side of the building, and they go out to the car. Mr. Hernandez gets in the passenger seat. I believe the driver's door is open. He then sits down, he dismantles his phone. He breaks it down into 3 pieces: the phone, the battery, and the cover taken apart. He then, the lawyer, goes to the trunk's open, and then the back seat's open as well. He's recovering something, but ultimately you see him hand a different phone to Mr. Hernandez. Mr. Hernandez then takes that phone and begins to operate it, whether texting, dialing, putting it up to his ear. He now has his phone broken down. At some point...
And is it clear that it's a different phone?
Absolutely, Your Honor. And in fact, what that is borne out as the video goes on, because he then restores, it appears he needs to get a number from his phone, he restores his own phone. And you see both lights now on the screen. He powers one up, and then he's looking at it, and then he's using the other phone. This goes on for about 10 to 15 minutes. And then he's then breaking down his phone again, making the calls. I've represented earlier those calls, the phone records would show, during the time that he's in the car, he's making phone calls to Ernest Wallace and talking to him on now this attorney phone. So he's, the Commonwealth's position, he's deliberately attempting to use a phone that has been provided to him so that he can make calls to one of his co-venturers, and has dismantled his phone and only appears to be now using it for the purpose of recovering numbers for contact information. So During this time, I think the door is open. The other individual, Robert Jones, is actually in the presence of, he's kind of at the door, sort of just alongside. I think the door is open. He's kind of leaning on it at some point. And then during this time, ultimately, he ultimately finishes the call, gets out of the car, and the video stops right there. So the only one, and this was, I had conversations, initially we blurred out the head of Mr. Jones. That was objected to. We then took that out, so it shows Mr. Jones, who wouldn't necessarily, it's not our intention at this time to identify him. It's just there's an individual there who hands him a phone. However, I've indicated that to connect that phone to that number, we have the situation when the police went, they executed the search warrant on the 18th, the police go there, there was ultimately that conversation with Robert Jones, and Trooper Joe Collins recovered his number. There was communications with him. I think there were 5 calls. As he then made his way into Boston, he met with him and he recovered the phone from him. He would be able to identify that number, and as well, he's identified a photograph of Mr. Jones, and as well the voice that he had spoken to on the phone.
How about the filming itself?
The filming itself, Your Honor, this is a what they call a tilt, pan, and zoom camera, so it can be manipulated. And in fact, when they're first observed in the scene, they're over in an area.
It wasn't manipulated.
It was.
So it was a conscious filming.
It was a conscious filming, and I think the detective would say they had come into the building. There were certain things. They then left the building. At some point, they're observed out in the parking lot, and they moved to the car. He then pans the camera to the car. So as to the suggestion that there's some sort of privilege, this is in a public area. It's viewable, particularly at the police station. There's now a deliberate attempt to engage in conduct to assist Mr. Wallace, to communicate with Mr. Wallace at a time by using a different phone, and now to suggest that somehow is protected, we would disagree with that argument.
Thank you.
Because, Ed, Your Honor, that in addition to panning, there was this zoom used. So Commissioner McCauley's argument seems to be, in effect, this is important and therefore it's admissible. I don't think he's really addressed the problems with what they were doing in terms of deliberately surveilling Mr. Hernandez and his attorney inside the attorney's private vehicle.
The defendant bears the burden of establishing that a search in the constitutional sense has occurred. There is a search in the constitutional sense only if the police have intruded into an area where a defendant has an expectation of privacy, which society would recognize as reasonable. Automobiles are accorded diminished Fourth Amendment and Article 14 protection based on their exposure to public scrutiny because they operate on public streets and in public parking lots, and their interiors are highly visible. In contrast to cases such as Podgorski, where the court says the defendant has a reasonable expectation of privacy in the rear interior of a windowless van that's parked in a lot. With respect to observation of the interior of a motor vehicle, the court must examine the situation in which the search took place and whether the defendant took normal precautions to maintain his privacy. There is, for example, no expectation of privacy in the interior of an automobile parked even in a private driveway if it is visible from a public road. An expectation of privacy in the interior of a motor vehicle depends on the nature of the activities involved and the degree of visibility. The court finds that based on the facts which I will make based on the representations of the parties and the failure of any request of the defendant to have an evidentiary hearing, that the defendant had no expectation of privacy in the interior of the automobile in which he was a passenger when it was parked in the police department lot, and a lot open to members of the public, such as the defendant and his lawyers coming to the police station. The facts, as appear to be agreed on by the parties, or at least the defendant has not requested any evidentiary hearing and doesn't dispute any of the facts by way of affidavit or otherwise, as recited by the Commonwealth, that Mr. Hernandez and an attorney from Robson Gray, Mr. Jones, were standing in the parking lot of the police station. They were observed. They then moved to a car in the parking lot, which was well lit. The camera was visible. A surveillance camera was visible on the police station building. Mr. Hernandez sat in the passenger seat. Dismantled his phone into 3 pieces. Mr. Jones handed him a different phone. Mr. Hernandez operated that different phone, at one point reassembled his own phone, and then spoke on the phone handed to him for 10 or 15 minutes, and then dismantled his phone. The calls made are relevant in that they were made to one of the alleged co-venturers. It appears from the recitation of facts, but Mr. McCauley, it appeared you were saying that Mr. Jones was not inside the car at the time Mr. Hernandez was making the calls. Is that correct?
That is correct, Your Honor.
Mr. Jones was not inside the car at the time the calls were made. The filming was an intentional, conscious act by the police, and the Zoom was used. Plain view police observation of criminal activity or evidence of a crime within an automobile without a physical intrusion into the automobile is not a search in the constitutional sense. Here the police observation was accomplished by means of video surveillance by cameras attached to the exterior of the police station to record activity in the parking lot. A person in the parking lot of a police station does not have a reasonable belief to believe that activity going on in that police station would not be captured by a surveillance camera. The police obviously had a lawful right to be where they were in the police station when the surveillance was undertaken. The fact that there was a Zoom does not affect the court's conclusion. Cases have even held that aerial surveillance of a private backyard is not a constitutional search, where there was not physical interference with property, and whereas here no conversations could be overheard, and the police had a right to be where they were. It is my understanding from a previous evidentiary hearing that there was no audio recording.
That's correct, Your Honor.
Fixed and intentional, non-fixed video surveillance of activities occurring in the parking lot of a police station does not violate the reasonable expectation of privacy. Neither the Fourth Amendment nor the Massachusetts Constitution protects what one knowingly exposes to the public. There are cases such as First Circuit Bucci case, where 8 months of surveillance in front of the defendant's house by a video camera was held not to violate the Fourth Amendment, where the police could have made the same observations in person, and although that was a case where the camera had not been magnified. in State versus Abbas-Lehman, 437 South 2D 181, a Florida Court of Appeals case in which cert was denied. The court said that even if a guard zooming in of security cameras to see activity inside a defendant's car could be deemed to be a search in the constitutional sense, there was no Fourth Amendment violation because the car was parked in a public lot, in that case a hospital lot, a place where the defendant had no reasonable expectation of privacy. The use of the zoom by itself does not transform the filming into an unlawful search. In Massachusetts, for example, while it's not a zoom, the similar concept, the courts have held that there is no Fourth Amendment violation when the police use binoculars to observe activity on a public street or public lot. The zooming in here is analogous to the use of binoculars by the police to get an enhanced look at something that is in plain view. In State versus Agaufa, a Hawaiian Court of Appeals case, the court drew that specific analogy to the zoom capacity of a fixed video camera recording on a public sidewalk, and as to whether that was similar. In the court, in that case, to binoculars, noted that the zooming in was similar to high magnification binoculars, as to which there is a violation only when the optical aid would permit the police to see activities that would otherwise not be exposed to public view. In other words, something that could not be observed at all by someone walking by the car by the naked eye. The delivery of a telephone, or the capture of the delivery of the telephone, the court finds does not invade attorney-client privilege, just like the delivery of any other object. If an attorney was handing an object, whether it be drugs or guns or anything else, that delivery from the attorney of a telephone to be used by the defendant, find does not change the analysis that an attorney who chooses to hand things to someone in a public lot, in a police lot where there is a surveillance camera on the building, is not having a conference with his counsel, with his client in a private setting. Indeed, I do recall from previous hearings that there were occasions in this case where during that time the defendant was at a station, counsel specifically walked away from the police station with Mr. Hernandez, out of the police station lot, and into the town or into surrounding neighborhood, were gone for some period of time, and did so specifically, the testimony was, because of a concern of wanting to be outside any perimeter of possible surveillance. So the counsel was certainly aware and took steps when they wanted to engage in behavior that was would be hidden from police cameras to leave the area. There were no restrictions on Mr. Hernandez from leaving the area. The The attorney-client privilege protects communications made in confidence for the purpose of obtaining legal advice. There's been no showing here at all that the handing of a telephone to Mr. Hernandez to be able to make, which Mr. Hernandez then used to call Mr. Wallace, was a communication made by the attorney to the client for purposes of legal advice. The court accordingly denies the request to suppress the surveillance video in its the request, which is to suppress it in its entirety. It seems to me that two questions or two issues remain, and they both with respect to this phone and the other phone, and that is, but it would require the defendant to agree to some stipulation, but there are a whole host of cases where a lot of cases from outside Massachusetts where evidence has been obtained from an attorney, and the courts have indicated that the evidence won't come in that it came from the attorney, provided that the defendant agrees to a sort of a, not really chain of custody, but that it was the phone he was operating. Here, it seemed to me that if there is not, if there doesn't need to be a tie-up to Mr. Jones, then I would require the film to be edited to just to leave out, to basically stop. He dismantles his phone to then leave out the handing of the phone to by Mr. Jones to Mr. Hernandez, pick up again when Mr. Hernandez is operating a different phone, and which you said is quite clearly a different phone, and in fact you indicated that it would be, at one point you see him with the second phone. So I think to the extent you just need to see him operating, dismantling his phone and operating a second phone, where that phone came from, whether it came from his pocket, whether it came from the, is irrelevant, unless you need to tie it to Mr. Jones and to this being Mr. Jones's phone number. And I don't know whether that if you need to tie it, you obviously would need to tie it in the absence of some agreement that telephone number, whatever that telephone number is the phone that was being that was the telephone number ABC is the telephone that Mr. Hernandez was using as pictured on the video. With that, you wouldn't need any information about Mr. Jones.
Yes, I agree with that, Your Honor. And what we had initially done, again, not identifying Mr. Jones, he's a man
I understand
who hands him a phone.
But eventually you would need
to connect him.
To connect him. But if there's an agreement that that telephone number is the phone number being used, then you would not need that to connect him.
Your Honor, I think
that... I've asked counsel for when the issue originally was raised, I did not rule on it at the time. The motion, I believe, had 2 or 3 sentences on this issue. Without any case law, I gave counsel opportunity to file a brief. Neither the Commonwealth nor the defendant has opted to do so, based on my research, denying that motion, which was filed as a motion to eliminate, but I will take steps to, as indicated, if the defense is interested in that.
I think what the court suggests is a good suggestion. We had asked the Commonwealth to delete the initial portion of the video, which is the portion that basically shows Mr. Jones with Mr. Hernandez, and then shows the phone being handed to Mr. Hernandez. We would be willing, Your Honor, to agree that Mr. Hernandez was making a call from that number, because that's the number they need to connect up with. I think using Mr. Wallace's records is what they need to do.
Right.
And so, we're willing to not, we're willing to agree that that was Mr. Hernandez who was using that phone at that time.
Right.
And with that agreement, we would hope that they would be willing, in exchange for that, we would ask that they be required to omit, I think it's the first 50 seconds or so of the video in which Mr. Jones...
It would have to show him, though, going to the car.
Well, they probably have a few seconds, yeah.
Right?
And that was my, that I think is where the dispute lied, because once he gets into the car, you can't see the top of his head. You can see his
Right.
body there.
I think they can show the first 5 seconds or so, show him walking to the car. There's then about 45 more seconds, which has Jones going back and forth and doing different things, and then has Jones handing Hernandez the
Right.
phone. I think we can cut all of that part out.
Right.
And Your Honor, I would just ask that that's agreeable to us.
And I understand that you would want a written stipulation before before that.
Yes, Your
I would hope we can proceed. The jurors were all here today at 8:30.
Yeah.
5, I saw them walk in. So I would hope that that your tech person can make those changes. So he's seen going into the car, and then it gets eliminated. The lawyer handing him the phone. Or the lawyer looking in the trunk and looking in the back seat and handing him the phone. So it stops after he dismantles it, and then it picks up with him operating the phone. And at the break, you can work out a stipulation. And,
Yes, Your Honor.
And I'll do a short colloquy with Mr. Hernandez after you do a stipulation.
That's agreeable. And Your Honor, the only point I was going to say is just that he then used the phone, not his own, because I think that's important, as opposed to the suggestion that he would have 2 phones on him. This was not his phone. I think obviously the evidence we'd be able to prove that, but I don't think we shouldn't be able to have that.
I will allow that. I think it's fair, just because the jury may then wonder where are the other phone records for that phone, and could draw an inference.
I'm sorry, Your Honor, what's the court going to allow them to do?
Well, it's really, the stipulation should be he was using a phone that he did not own. So it doesn't say who owned it.
Right.
But that it would
A
eliminate...
phone other than his own phone.
Right, it would just eliminate the jury wondering why the Commonwealth has not produced other phone records of that phone.
Very well.
Or what Mr. Hernandez could have been doing with that phone. And you may, during the break, want to also discuss a stipulation with respect to the other phone, which would eliminate all evidence of going to Ropes and Gray to get the phone. And Mr. Wording in that one may be trickier, but or simply that whatever that phone is, whatever that exhibit's going to be, was Mr. Hernandez's phone and was in his possession during whatever time the time frames are of the telephone calls you're going to introduce. And that would eliminate all going to the office, the conversations, and that's how other states have dealt with, that's how many other states have dealt with the issue of getting evidence from an attorney.
We'd be happy to try to work that out, Your Honor, at the break.
Thank you. Can we bring in the jurors now?
Yes, Your Honor.
Thank you.